Now streaming.
Yes, I think you are good to go, Judge.
All right, good afternoon, and bar staff, bar counselors, members of the subcommittee, and invited guests. I'll begin with the conflict statement for the members of the subcommittee. You are hereby advised of your duty under the State Government Ethics Act to avoid conflicts of interest in the appearance of conflict, and are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest or the appearance thereof. Anybody? All right, seeing none, we can begin our meeting. This is the inquiry of staff, a real estate client referral to a law partner's business. This inquiry has received considerable attention from the general bar. I can tell you that I have read all of the letters sent to me over the past week or so. I know Mr. Oaten is familiar too and has a grasp on all the competing contentions, and I assume that members of the committee have also familiarized themselves with all the letters that you've sent. But I do want to give each of you guests an opportunity to introduce yourselves before I turn it back over to Brian to tell us where we are at as a subcommittee with this issue. So how about Kyle Smalling? You're on the screen.
Right. Well, thank you everybody for having me here today. Again, I'm Kyle Smalling. I've been a private practice attorney since 2014 in my own firm, starting in Raleigh. We have a few other locations now. For the last 7 years until the middle of this year, I also served as consumer protection attorney for the North Carolina Bar Association Real Property Section, and have rolled on to this fall their executive counsel. But I think I've submitted a letter in discussion of this inquiry or these set of inquiries, and happy to share my own personal opinions on everything. And again, appreciate the opportunity to be here.
All right. Thank you, Mr. Smalling. Amy Richardson.
Thank you so much for having me. First of all, I'm actually a former member of the Ethics Committee. I've been on one of these subcommittees on an issue. I'm actually here because I'm representing Nathan Zaleski, who is a gentleman who owns both a title insurance company and a law firm. And so I thought he submitted pretty lengthy materials to the committee. So we're here to kind of speak on his behalf and on some of those issues. So again, thanks for having us.
Thank you, Ms. Richardson. Malia Williams.
Hi, thank you. Thank you for having me. I am Lee, as you said. I practice primarily in residential real estate with some commercial as well. I'm licensed in West Virginia, South Carolina, and North Carolina. This past year at the annual meeting for the Real Property Section, I was recently appointed to serve on the Real Property Council, and I serve as co-chair for the residential section. I am also in my second year serving on the board of directors with RELANC, so the Real Estate Lawyers Association of North Carolina. And I'm head of the real estate department at Craig Jenkins, Lipford and Walker, which is the firm that I practice at, located in Winston, North Carolina. I am sharing my opinion not in any of those official capacities, so it's not reflective of my firm or of those roles, but that's a little background of who I am and what I do.
Thank you, Ms. Williams. Ms. Nancy Ferguson.
Hi, thank you. I just got my sound working, so I've missed everything until this very moment. I'm Nancy Ferguson. I was with Chicago Title, and before that with Lawyer's Title for the last 35 years, but retired a few weeks ago, and am now just basically consulting with different people on different things. Happy to be here and hope I can help.
She's also written a book called North Carolina Real Estate with Forms that I have a copy of, and she's a noted real estate expert, and I'm anxious to hear what she has to say.
All right, good to have you, Ms. Ferguson. Mr. Jeff Benson.
Thank you, Your Honor. My name is Jeff Benson. I'm with Investors Title Insurance Company. Before that, I practiced real estate law in North Carolina for about 24 years in a law firm, and then was in-house with a real estate investment firm for about 7 years, and have been Investors Title for about 3 years.
Thank you. Elizabeth Johnson.
Hi there. Sorry I was late. I just got hung up in another thing. I'm just a member of the subcommittee and interested to hear more of your perspectives.
Brocker Law. Who's the
Oh, you're on mute, Deanna.
Sorry about that. Hi, can everybody hear me?
Yep.
Okay. My name is Deanna Brocker with the Brocker Law Firm. I am here because I'm interested in this issue for a couple of different reasons, in part because I've represented a number of lawyers over the years that have asked me this very question, including Mr. Zaleski, whose materials you've received, I believe. I've represented a number of lawyers who have either received ethics advice from the state bar on this issue, or I have requested advice from the bar on this issue on their behalf over the years, and so I'm very interested in hopefully the bar coming out actually and consistent with their prior advice, but we'll see what happens.
All right. Thank you very much. Have I missed anybody, any of our guests? Okay, very good. Well, just before I turn it back over to Brian, a lot of the materials address inquiries that have been previously addressed by the state bar, albeit under a prior set of rules. But it has opened a general discussion about this issue broadly. But the actual inquiry before this subcommittee is a referral to a law partner's business and any imputed conflict. But this is as good time as any, though, to revisit other changes. If there were to be a change made based on the most recent inquiry, it may require us to reconcile that with prior opinions. So with that, I'll turn it back over to Brian Oaten.
Yeah, thank you, Judge. So just as a recap, not just for our subcommittee members, but all that are joining, and as well as everybody on that's potentially watching on our YouTube stream. I don't have that pulled up right in front of me, but I imagine there are some folks watching. This might be the moment that the state bar goes viral. So I'm very excited about that. It looks like there's 62 people watching right now. So watch out, Mr. Beast. As far as where we are at, this, like the judge just said, we introduced this inquiry focused on three questions, one of which was kind of a rehashing of the question that has been answered by North Carolina Ethics Opinions as to whether or not a lawyer can serve both as closing attorney and title agent. Like the judge said, we are kind of re-examining that, not necessarily to, I guess I want to be clear. It's when I say re-examine, it's more of just kind of I feel like a foundational issue for the subcommittee to look at that issue, because North Carolina is different than other states. And I hope that we have a good discussion today about the difference between North Carolina and other states that have a different conclusion on that question. But the real question that was presented to ethics staff over the years that I think has produced additional discussion has been whether or not right now the answer to that first question being that yes, it is a conflict for a lawyer to serve as both closing attorney and title agent, but is there a conflict that's imputed to the rest of the firm when the closing attorney is basically procuring title insurance through the company of the title company, or excuse me, the title agency that's owned by their partner? Is that an imputed conflict based on that financial interest, or is that a personal interest conflict that does not impute to the rest of the firm? Is there some amount of disclosures that cures it? All these different things that kind of factor in there. The last meeting that we had, we started the discussion, and I think the subcommittee realized we need to hear from a lot of different perspectives. Some folks feel very strongly that the current system in North Carolina, the answers to those questions should remain the same. Some feel that they need to change. And so I went about, myself and Britt McInnes, we both really tackled the issue of how do we reach out to some folks, get some names, get some participation, and you all that have been invited to participate, thank you for your time. Thank you for your thoughts and just sharing your perspectives here, because we're trying to figure out, what is the best answer here for the benefit of the public, for the protection of the public, as the State Bar's mission stands. So that's the purpose here. Nobody has been asked to present anything or create some sort of formal presentation. This is really supposed to be an opportunity for us to discuss those questions, to understand a bit more about just real property practice. We have some real property practitioners on the subcommittee. Others on the subcommittee do not engage in that practice, and so we want to get that full perspective. I will add that we did receive, as Judge, as you mentioned earlier, a lot of different feedback since the last subcommittee meeting. And that's the thing that's tough about receiving feedback at this time is that there is no proposed opinion for the subcommittee to consider at this time. So any feedback is really on something that's just kind of, I guess it's pointed in the direction of this topic, but it is not yet really reflective of what the subcommittee is proposing the answer to be. And so to all that are watching, I guess I would suggest, as I have in the past, I'd strongly suggest holding off on submitting any sort of commentary until you have a proposed opinion to comment on. That said, we have supplied or provided the subcommittee members with all the different submissions to date, and that's where I know some of you have been involved in some of those submissions as well. So I guess at that point, we are still exploring this issue. So we don't have an opinion to start going line by line, inquiry by inquiry, seeing whether we like the answer or not. This subcommittee is still tasked, or still at really kind of the infancy stage of what is the answer even supposed to be. And then we have to tackle the question of what format do we publish this answer? Is it a formal ethics opinion? Is it an ethics decision or anything like that? There's all sorts of different things that we need to figure out before we get to the point where the subcommittee actually has some sort of work product. So I think the purpose today is to hear the different perspectives, to understand this issue as well as we can, understanding that everyone participating, I'm going to take the nerdy moment and say thank you all for participating in the self-regulation of our profession, and contributing your perspectives, because it's going to make the profession ultimately better. But with that said, Judge, I would, I guess, hand it back over to you and the subcommittee to say, I don't know where we want to start first. I know Mr. Benson submitted some thoughts, as did Ms. Ferguson. I know Amy Richardson's client submitted a lengthy document as well with his thoughts. I don't know if he's planning to attend. Amy or Deanna, do you know if Mr. Zaleski is planning to attend?
I have pinged him and I will answer that when I can.
Okay, great. But nevertheless, I think we just can start by talking. I don't know if there's a subcommittee member that has a question about any of the materials or the inquiries, or if we want to just kind of start going through and getting everybody a chance to be heard on these different inquiries.
All right, anybody on the subcommittee want to lead things off?
Well, I hate dead air, so I'll fill it.
I was going to call on you anyway. So,
for those of you who don't know me, my name is Craig Lynch. I practice commercial real estate law with Parker Poe in Charlotte. Many of you I do know. And I guess one of the things I was worried about is some people that submitted materials said that this could be an inflection point where perhaps if we didn't change, that the state of the industry in our state would have a dramatic shift and basically be a shift from attorney-run operations with respect to closings. I would think primarily on the residential side. And I'd be very interested in your take on that. I'm not a residential person. I know we have several people on the call who are, but I just wonder what the genesis of that concern is.
I can start, Craig, and Kyle and Malia may have closer, and Nancy may be closer to this than me, but I don't think that's a correct statement. I don't think there is any inflection point. There's no motivation that would cause keeping the current system in place such that we evolve into something other than an approved attorney state like we have in North Carolina right now. I think there's a lot of very strong defenders of the attorney system that we have in place in North Carolina, including our company, including the other people who are on this call, I believe. So I don't know. I don't think basically the bottom line, Greg, there is nothing that would cause keeping the current system in place to somehow switch so that we are no longer an attorney state. I think it's actually just the opposite. If you begin to go down the road of change, you've opened Pandora's box that we could wake up and be like Virginia, which is no longer an attorney state, and attorneys have been cut out of the system. So I think it's actually, if you answer yes to the inquiries, you're more likely to go into a direction that is unpopular among the real estate bar. I don't know if Nancy or Malia or Kyle, you have any additional thoughts around that?
I'm happy to step in. I've spent the last few days obviously talking to people in our various states, and I was here when CRESPA was adopted in Virginia and that battle. And of course, Georgia's got a battle going on too. But what they tried to do in Virginia was, of course, create an attorney agent state. And what happened is the whole thing slingshotted in the exact opposite direction. And that was in, 96, I think. So it's the risk, and at the risk of saying something about politics, the risk right now is that anything we do to give attorneys more ground may slingshot against us in the legislature, because we do have statutes that we do have to deal with. So if we change some of these things, and I'm not advocating for either side necessarily at this point, though it may be clear what my opinion is, but I think that's the risk, is that we'll come up with a situation like Virginia where attorneys do own agencies, but they don't do much title work anymore. They're pretty much using the agencies, I think, for the closings, and a lot of lay agencies are doing the closings, and they don't have titles done by attorneys anymore. So, I mean, it's been a major slingshot. There are states like West Virginia and South Carolina that have attorney agencies, but they've had them for decades, like since the beginning. There are states with variations, but most of the states that are from Mississippi West, certainly, they don't even have attorneys involved in the closings, unless it's a commercial deal and the attorney is literally doing legal representation. And that's because of the historical anomaly. They're just different from some of the eastern states. We have a website, I'm sure investors and other insurers do too, where it walks through what the standard closing practice is in all 50 states. And most of them are not attorneys. Or if they are, they're just doing it because they have agencies, and it's not because they're an attorney, it's because they have an agency. So that's my 2 cents on that question.
And Nancy, who protects the consumer? I do a lot of, my name's Martin Scott. I do a lot of residential work, a tremendous amount, as far as down for Southeast North Carolina and Columbus County, which nothing compared to, I'm sure, a Charlotte or Raleigh, but pretty good for down here. Who protects the consumer when there's an issue about an easement or a line dispute or anything coming into closing and the title work that's done, and then of course the closing itself when you get there and suddenly the lender's charging a rate they didn't disclose before to the buyer? Because I don't do Virginia work.
Yeah. Well, Virginia, again, they still have a UPL statute, which is about legal representation. So if there's actually a legal dispute, like an easement dispute, or in a commercial deal like Jeff used to do and still does on the title side, you could still have an attorney out there involved in the legal representation. They just wouldn't be doing the closing itself necessarily, wouldn't be doing the disbursements, wouldn't be doing the title work. And most other states have title plants, so they don't even have attorneys involved in the title work. The attorneys are strictly looking at the legal issues that are involved in the transaction, and then presenting the legal the documentation. It's sort of like 2002-1 APAO in that they're not supposed to commit unauthorized practice by giving legal advice, but you know how that is.
How do they not?
Well, you and I look at a closing as being a compilation of a lot of advice, but it's not so much in some other places. This is why this is a scary kind of a proposition. So,
Well, and I guess this will lead into a little bit of the others, and I don't want to dominate everyone's time. So not a lot, but numerous of these opinions that we've gotten from folks tend to indicate that this is already going on with consent, with information and consent, that this can already happen. And they're citing back to the statute under the insurance regs under 58 that this is allowed because, of course, you can, just by owning an interest in a title company and receiving a dividend, does not in of itself constitute a conflict according to some of the stuff, the information I've been receiving. The other information I'm receiving, of course, takes the opposite perspective, which says, no, you can't do this. This is violation. How do we reconcile that? Because I'm really curious. I mean, I read the statute and I was hoping there were some annotations. Of course, there are not. It's not been litigated. And so how do we bring some sort of common ground if it is right now allowed or it's not? Because based upon what I'm hearing, there's no common ground. Either it's a yes or a no answer.
Are you asking a common ground on allowing basically a yes to these attorneys to own agencies?
To own agencies or refer to a partner in their firm who owns an agency.
Well, I don't think we've ever had an ethics opinion or a statute that would allow an attorney to own an agency or an attorney to self-deal in the way that a yes would mean for anything. I don't think we've ever had that. I think we've had the statute from 73 and it's been updated a few times. And then we've had a series of opinions that have basically answered, no, you can't to have that either an attorney owning an interest in an agency, or in another case, similar things where like a spouse would have an agency and the attorney would self-deal with the spouse's agency. I think the bar has been consistent since the 1970s that the answer to those questions is absolutely no, you can't do that. I don't think there's been an ethics opinion that says that that is permitted.
In North Carolina.
In North Carolina, yes, to be clear.
Right, limited North Carolina. But okay, so we still have this statute 58-27-5. Is the bar out of touch with that and not taking that into account, which section C says no person or entity shall be in violation of this section solely by reason of ownership of stock in a bona fide title insurance company, agency, or agent. It doesn't tell me a whole lot on those words. So what do those words mean with regard to referring to a partner who owns a title company? Is that a yes or a no? Can we not do that, or can they do that?
Well, I can say that the bar has been consistent for 50 years in saying, no, you can't do that. I mean, there has been, both from the standpoint of how the bar has been operated. We are not a attorney agent state. We have never been an attorney agent state. So the practice in North Carolina has been consistent since the 70s that the answer to that is no, you cannot do it.
Okay, so the attorneys who
are not doing it. I mean, you could, it's if you asked the leadership in the real property section, they would be very clear. The answer is no. The current rules are no, you can't do it. And I guess the concern is now that the bar is considering changing that.
I might add, if that's okay.
Yeah. Mr. Zaleski's joined us. Well, introduce yourself first, and then we'll hear what you've got to say. Welcome to the meeting.
And you're muted, so it's really hard to hear you.
Sorry about, there you go. So my name's Nathan Zaleski, and I am the owner of Sterling Law and Sterling Title, and I did submit some materials to the committee for consideration. I appreciate y'all taking a look at those. Just one point that I had heard was that, oh, you know, the bar has been consistent. The bar in their original ethics opinion in 1964 said that it is ethical for an attorney to own a title company and serve as the closing attorney. I put that in my brief. It has changed as the ethics rules have changed. And then the last ethics change was, of course, in 2002, which said the change in 2002 basically allowed business transactions with clients, which is where we are today. So I just wanted to, I could say a lot, but I just wanted to kind of correct that one point that the bar used to allow this, which is, of course, the same thing that is allowed in South Carolina, Georgia, Virginia, Tennessee, Florida. Like, let's just go down the list. Just about every state in the country allows this. So the fact that we're sitting here talking about whether attorneys can do this, like, we are an outlier on this issue if we don't allow this in the extreme. And I just want to make sure that we're all clear on that. I mean, the American Bar Association has had a rule and has been consistent since the 1970s that this is allowed. And that opinion has been adopted by South Carolina and Tennessee as an example. So just to be clear that there is not a bright line. We've never done this in North Carolina. The truth is the original position of the bar was it was allowed, and I included copies of those old ethics opinions in my materials.
If I might, the 60s, you're right. You're absolutely right, Nathan, that was the case in the 60s, but that predated the statute. 58-26-1 was adopted in 1973. And that's the rule that kind of separated, did kind of a church and state separation between the attorney searching the title on the one hand and the title company issuing the title on the other. And that has kind of flipped the paradigm. And since that 1973 statute, the decisions of the bar have been entirely consistent that attorney agents is not what we have in North Carolina, and that there really hasn't been a formal ethics opinion to the contrary.
Those opinions followed the rules of professional conduct, not the statute. I mean, the decision has always been made under the rules. You know, when the rules of professional conduct said that you couldn't enter into a business transaction with client, then the bar said, well, we can't engage in any kind of business transaction, including the sale of title insurance. And by the way, there are other opinions for other practice areas that said the same thing. For example, selling of life insurance or engaging in other areas. However, since 2003, the bar has had a new policy because we've had new rules, and that's the world that we're living in. And if you look at 58-26.1, which is the statute you just referenced, I mean, that statute is actually referring to the title insurance underwriters, not the agencies that would be owned by the title insurance company. It refers to the companies as the ones that would have the reserve requirements. And in any event, it basically what that does, or what that statute is clearly intended to do, is it's designed to prevent a title insurance company from employing an attorney in-house and having them turn out opinions. So it basically prevents the title company from owning the attorney. It's not designed to prevent attorneys from owning title companies. I think we're looking at it from the wrong way.
I don't think that's how the bar has seen it, though, Nathan. I think that that's not how the interpretation, or maybe it's just independent of the statute. But you mentioned 1.8, which was revised in 2003. I don't think the change in 2003 to 1.8 in eliminating the prohibition and eliminating a blanket prohibition, I don't think the bar was saying, okay, now any business transaction between a client and an attorney is okay. And the spousal conflict, that spouse owning an agency thing, that was adopted post 2003 and referenced the fact that the principle is still in place between kind of that separating of the principle. In fact, if you read that what's the site for it? I'll get it in a second. It's 2009 FEO 14. I'd encourage the committee to look at that pretty carefully, because some of the language, you couldn't be more on point for the topic that is under consideration. And the bar was very clear that it would not be permitted, that it would not be okay to have.
And to tack on to that, we have recent opinions, 2023 FEO3, which was mentioned on the last call, the kiosk decision. I don't think the bar has stepped back from their position as to this conflict here.
So Kyle, since you're the one with consumer protection experience specifically, and you just mentioned that, which is what I keep coming back to, because I was on that in those discussions as well. Can anybody on the subcommittee tell me how he or she thinks that issue can be distinguished from this one?
Brian, for those who are not familiar with the kiosk decision. Can you sum that up for us?
Sure. I will confess it might be one of the more boring opinions that we've drafted. But nevertheless, it's the inquiry there was that an attorney wanted to know if they could have a basically a kiosk in their law office that permitted the client or his clients to get kind of like interlock services basically for DWI charges. The scenario there was that a company wanted to basically rent space in the office to put this kiosk, and the clients could avail themselves as they needed. But the inquiry kind of had a question of renting space versus maybe the attorney getting $20 for every client that uses the kiosk, things of that nature. And ultimately, the opinion says that the financial interest that the lawyer had in that kiosk remaining not just in the office but also being used created a conflict that could not be done away with by way of waiver, and that was citing back to some of our earlier opinions. And I think it kind of references even some of the commentary in Rule 1.8, particularly I'm thinking of comment 3 to Rule 1.8, where it talks about business transactions, that there's the permissibility of a lawyer to engage in some sort of business transaction with a client is not just kind of absolute. It's not absolutely prohibited. It's not absolutely allowed. It's something where there are still considerations for the client's expectation of being represented in that transaction by the lawyer, or when there's a financial interest of the lawyer that poses essentially a significant risk to the lawyer's independence, their ability to represent the client in the underlying matter fully without being limited by consideration of their personal interest. And that was the last sentence of comment 3 to Rule 1.8 says something about the lawyer's interest may be such that Rule 1.7 would preclude the lawyer from seeking the client's consent to the transaction, and that was referencing that financial interest there. So that's the kiosk opinion. It kind of is the same question put in a different way for I guess more of today's consumer experience.
So Gina's question is, can we distinguish that opinion with this inquiry?
I think there is a distinction, which is that opinion, despite coming down against this kind of kiosk related relationship, it openly discusses that interaction between the lawyer and the company providing the kiosk, it is only an indirect relationship. Here, we are talking about a very direct relationship between the title company owned by the attorney and the attorney providing the services. So I think there's a distinction, but it actually cuts even stronger against positions for change on this issue. So I think if the kiosk was a hard decision, that this should be an easier one than that. I don't know that it was.
It wasn't hard.
We don't do that kind of work in my firm.
Ms. Ferguson, your hand up.
It is. I just didn't want to interrupt. I have just a couple of observations, and there are key distinctions. Number one, North Carolina has always been very attorney consumer protection oriented, which is why we have Kyle and we've had his predecessors through the real property section, and the Bar Association. So I think we do need to keep that in mind, absolutely. A lot of the other states, their definition of the unauthorized practice of law is very much more limited than ours. It does not even touch real estate. So we're looking at a totally different statutory structure in that sense. And that's statutory. I mean, we can't change that. It says what has to be done for title work. And I think the other distinction in North Carolina is just thinking through, there's this sort of assumption that it's title and closing. Well, they're not the same. They may be two totally different attorneys involved or two different groups of people involved. So when you're thinking about how to structure a response to this for title insurance, that doesn't necessarily mean it's the closing attorney. Because I mean, most commercial transactions anymore, there are multiple attorneys involved, and the title examining attorney, title certifying attorney may not even be one of the attorneys who's actually representing the parties. So, and a lot of firms have title agencies, but do no title work themselves. So that's becoming more and more a norm just in the way it is. Probably not residential, but it is in the commercial world. So I would say any distinction here ought to take those into consideration. And I guess my last consumer protection issue would be that any disclosure be very robust. Most of the ones I've looked at in other states have not had really robust disclosures about things, because title insurance is really very different from practice. I mean, I've done claims for the last 35 years, working on underwriting and claims, and 99.9% are not attorney error. I mean, a lot of them, I mean, they may be for other companies. I can only speak for mine. But most of what title insurance covers is not attorney error. It's all those other things that we cover. For example, things that were prior to someone tacking to a policy, or things that were prior to a title examination, an old right-of-way, an old easement, a ambiguity in an old piece of property line. I mean, those are the kind of things that or an ambiguity in what the law is. Look how long we litigated the Marketable Title Act, and we're still not sure where we are with that. So most of the title claims in quantity and in losses and expenses are not about attorney error. So title insurance and the underwriting and the questions you ask are very different. I was shocked when I came out of practice, and Jeff can probably tell you that too. It's just different. So I think those in the background are the issues I think need to be there when you're thinking about the consumer protection issue and how you want these opinions to go. Because the attorneys that are going to be doing this, if they're going to be attorney agents, I would say we really need a very robust consumer protection type disclosure and very clear guidelines, like we did in APAO 2002-1 and like Virginia's done in what they did in CRESPA.
So and Amy, I see your hands up. I have a follow-up question though, and this is kind of to Nancy, but also anybody here. And this is coming from my place of ignorance. I've never conducted a closing. All right. So just forgive me for that. What's the benefit or what is the downside to North Carolina's structure in terms of consumer protection? Like you're talking about the different things. What's the benefit to having this, I don't know, I guess like an arm's length deal, essentially, or an arm's length sort of separation for the closing attorney and having somebody else that's not affiliated, whether it's the closing attorney or whether it's the closing attorney's partner, who is the one procuring the title insurance or owning the title agency. And I guess kind of a corresponding question is, you know, do other states and their different answers, do they better protect consumers or is it worse for consumers? And I'm just wondering what the perspectives are here.
Can I jump in with that start, Brian? It is a very central thing that I would say with great confidence that answering yes to any of the three questions is harmful to consumers. It will be harmful to consumers. There's zero benefit to consumers by answering yes to any of these inquiries. It's all harm. There's a couple of key components of what that harm would entail. The first one I would say is our rate system in North Carolina. The rates of title insurance premiums that we charge in North Carolina is very, very low compared to other states. If you rank them, 1 is the highest, 50 is the lowest. We bounce around, what, Nancy, probably 48, 49 typically. So there may be at any one time 1 or 2 states cheaper than North Carolina, but only that. And it's not close. It's, Georgia is roughly 2 times what North Carolina is from the standpoint of rate. South Carolina is about 1.5 times. And there's a variety of reasons for that. One of the key reasons is we have a very low claims environment in North Carolina. So when the Rating Bureau and the Department of Insurance set rates, they consider the claims rate in North Carolina. And we have a very low claims rate. Even though our premiums are less than half of what they are in Georgia as a state, our claims ratio, which is the numerator would be the loss by claims, the denominator is the total amount of premiums in the market. Even though we have a much smaller denominator, our denominator is less than half of Georgia, our claims loss ratio, again, numerator being loss, denominator being premiums, is basically the same as it is in Georgia. So we have significantly lower claims in Georgia. If we switch to a system where we are more like Georgia, what is now a downward pressure on rates is going to flip and become an upward pressure. So why do we have a lower claims environment? The principal reason is right now we basically have, for lack of a better term, a two heads are better than one system in North Carolina. So Kyle or Malia, they search a title, and as they have questions, they're asking us. They come to an independent bifurcated system and ask us questions. Or when we get something from them and we notice something isn't right, we can kind of raise our hand and go back to them. That kind of division of labor, or whatever you want to call it, fosters a very low claim environment in North Carolina compared to South Carolina and Georgia, which are two states that are pretty similar to ours, but for the attorney agent factor. So if you just say, okay, we're going to snap our fingers and we're going to try to be more like Georgia, we should expect our rates to go up. It's just going to happen as the claims go up, as the system changes. That is a significant issue of consumer harm, I would argue. I mean, they're just going to pay more. The other element is attorneys right now on a consumer protection issue, they have a kind of a singular focus. When Kyle represents or Malia represents somebody in a closing, or Martin, their sole focus is to represent the client in the procurement of title insurance. They want excellent title insurance at a low cost. That's what they want. And so if they call a title insurance agent or a title insurance company and they ask a bunch of questions and they think they can get a better result somewhere else, they do that. They kind of vote with their feet and move that business over. And as a result, the client gets excellent coverage. In the case of an attorney agent system, you basically have no competition. It's a competition of one, where the attorney is feeding its own agency business. So you lose some of the benefits of our inherent system that keep our rates low. And instead of the pressure going down on rates, the pressure goes up. And what happens is in states like Georgia and South Carolina and other states, what you see is the customer is paying more for a lower quality title insurance. The rates are higher, but attorney agents have an incentive to keep the coverage limited. So you have a lot of general exceptions and those sorts of things, which limit the effectiveness of the policy. So they pay more and get less in other states, including Georgia and South Carolina. That's the system that's grown up there. North Carolina is more protective of the consumer. Whoever said that a moment ago is correct, that our history this is Nancy, our history in North Carolina has tended to be more consumer protective, and that's the status we are in today. So if you answer yes to any of these, you're going to move more to a system where the rates are higher and the quality of product is going to be lower. And that's not speculative. We see that happen in the states where, that would be our new model.
Amy, you had your hand up earlier. Do you want to add anything?
I mean, some of it responds to that topic, but I just want to make sure if there's anybody specifically on that topic. I also wanted to talk a little bit about the protections, I think, for consumers and having our ethics rules also be part of these disclosures. So just want to be careful as anybody wants to go to any other point there.
Can I ask a quick question that relates
Yes,
to what Jeff was talking about?
Yes,
and
please.
It's pretty simple, but I know that many of the people that are on our subcommittee don't necessarily practice real estate law, but maybe Jeff or anybody else who's got ties with a title agency, can you kind of explain to us the difference between a title policy that might say all matters of record are exceptions to the title versus a laundry list of specific exceptions, like there is a gravel driveway that serves as an easement in favor of adjoining property. Just an example, but I know you're probably much better at explaining that than I can, but I think that would be beneficial because I think the more streamlined kind of exception may be something you start to see a lot more often if we were to change the paradigm.
I mean, I can speak on that from the attorney side. Right? If I have a client come into the office, right? And we get a survey, right? And a survey shows a 20-foot stormwater easement on the east side of the lot, right? I have two options. Well, I have dozens of options now because we have a good amount of consumer choice on the title insurance side. But I can send that information out to a title insurer, and they can send me back a policy with exceptions. And some of them are going to send me back something with a very blanket exception for all easements of record, and some are going to send back a policy that only has one exception for that one easement that was identified. The consumer, once the transaction is done, they have a more valuable policy. They don't have an open-ended list of exceptions for easements. Let's say there was another easement at the back of the lot for a 50-foot overhead power pole line, right, or power easement. That fundamentally diminishes the value of their property. And depending on which of those two policies I went with, and provided I didn't argue back against general broad exceptions, that consumer, when they find out about the overhead power line easement, is going to have a direct financial loss that may or may not be recoverable depending on what policy and the quality of the policy that issued at closing. And so I would echo what Jeff says. That choice issue is important, and different title insurers take a different approach on that question, right? As to general versus specific exceptions.
And then to pair off of that as well, to speak to what Nancy had said before, when it comes to the practice of real estate being different than the title insurance side of things, when we are naturally obligated to be competent in our practice of law and what we are doing in a real estate closing with the conduct of that, as Kyle was saying, we have different options with who we can consult with whether or not an exception would be applied. But we also, I don't know all of the intricacies of how underwriting functions because it's not my role as the real estate attorney, but I can tell them what their risks are. I can go to the title insurance company in-house counsel and ask them what exactly needs to be added so that we have affirmative coverage over a potential issue that may have exposure for my client. Whereas if you give independent ability to be able to just make that decision as the closing attorney and write over it and put the exception on there, that way they can proceed with the closing, that additional cushion and that additional protection is not going to be in place. North Carolina has never, at least historically from all that I've read so far with this, been opposed to being different from the rest of the states in the US with how we function with real estate. It's an extreme benefit to us. There are several title claims that unfortunately we have seen, but there's one in particular that I'm working on where it was conducted from an attorney that is based in Virginia, but is licensed in North Carolina and doesn't know how to search title in North Carolina. Every single county in North Carolina is different and has idiosyncrasies that are unique to them, that if you are not local counsel or consulting with the Register of Deeds office there or someone that actually actively practices in our state, you're not going to know what those are. And you're just signing off on issuing this policy, and your client's going to think that they have the protection, as one would, because they have insurance and that's what it's for. And then they find out at the end of the day when the claim comes in that they don't, because there are these exceptions that exist to that coverage. And so that's where a lot of, personally for me too, as a younger attorney in the scheme of my colleagues and everyone else that's submitted the opinions so far, learning about title insurance and learning about how to search title is much like learning the Greek language. And it is for real estate practitioners in the beginning as well. So if you're being told as a new attorney to search the outs and check this and check that, and you're learning how to even conduct yourself with a client, if you're making a decision as you're making 500 a day, as we all do, no matter what our practice areas are, as a new associate, you're going to believe that you are making the quote unquote right decision if the answers to these inquiries is yes. If you pick Bob, the senior partner's title agency, whether or not you know anything about how they conduct their business, how the coverage functions, because in your mind as a young new attorney, that's the right decision and you're doing what is abiding by your firm and your practice. So I don't think there's any question on these, and to echo what Kyle had said earlier as well, I think this should actually be a much simpler discussion than what it's turning into. And I think what we're seeing is a deviation from what the purpose of our ethics rules actually is, which is to protect the public. And a lot of what is the motivating factor for this is to increase income and revenue. So I think we just kind of need to zero in and call a spade with that portion of things. I think that's really what is motivating a lot of the pushback when it comes to wanting to change this. We are an attorney closing state, and that has been unique to us, and it's been a benefit, which is why we have lower claims.
I got to say, I'm curious what Mr. Zaleski has to say, because I know you, Mr. Zaleski, you were advocating for a change in this process and a different answer. How does your proposed answer better protect consumers?
Well, I'd like to start off by saying I love that we're an attorney state. We should absolutely be an attorney state. I mean, I'm an attorney, and I think that attorneys are the best people to do closings. Not only are we the best people to do closings, we're the best people to own title companies. And the fact that we have these skills will translate into other areas. I'd like to push back on this whole idea that there's somehow some kind of something wrong with the attorney owning the title company. I mean, the fact of the matter is the attorney has a duty to the client, and that is to act in the best interest of the client. And if I'm going to, if there's a third party title insurance company that has no connection to the client, they've got no duty to that client. I mean, they would be quite happy to insure as little as possible. But if you have the attorney who has an actual client that they're trying to advocate for, they're going to go ahead and make sure that policy is robust. So the whole idea that closing attorneys are going to sell their clients down the river is just completely wrong-headed. We're their advocates, and we're in the best position to go ahead and help them. And I know that there was a mention here about, well, it's about revenue. Well, there is a revenue component to this which cannot be ignored. But the fact of the matter is if attorneys are able to get revenue on both sides, they're going to be able to offer a package at a lower discount. And under RESPA, it's called a bundling discount. If you offer affiliated services together, you're allowed to offer a discount for the bundled services. And so this whole idea that it's going to cause an increase in cost to the consumer is backwards. If it's going to cause a decrease in the cost to a consumer, because attorneys are going to go ahead and be in a competitive environment with other attorneys, and we're all going to be competing for the business. Right now the title insurance companies are just kind of getting fed by the closing attorneys. And ultimately we have to ask ourselves, do we want the title insurance company to be run by people that are subject to the rules of professional conduct, or a layperson who's not subject to anything? And fundamentally, that's the question. And why is it better that the other side, I mean, which is, it's not controlled by an attorney? So ultimately, we're the best people to go ahead and advocate for our clients. And when we have relationships with an underwriter, we can go ahead and leverage that relationship for the benefit of our client. Like, for example, if I'm looking at a policy and say, you know what, I really would like that exception removed. Well, they're more likely to do it if they're in a business relationship and receiving future orders from that attorney. So the attorney will be able to leverage that business relationship, for the benefit of their client. And I think there was another point that was made earlier, that right now we have a better system because two heads are better than one, where we have the title attorney, we have the closing attorney, and then we have, title insurance, attorneys as well. Well, that doesn't change if title insurance companies are owned by attorneys, because right now, with Sterling Title, we have access to all of the underwriting attorneys with the underwriters. And so we're constantly in touch with them, and we are getting the benefit of two heads are better than one. So there's nothing lost if we go ahead and we were to open this up, which I think already happened in 2003, but other people might disagree. So all the way through, the attorneys are best suited to protect clients. And the whole idea that we're going to be better off with lay people doing this just doesn't pass the comment.
Ms. Richardson, you've been very patient, polite with the yellow hand. Did you want to be recognized?
Well, Nathan took care of some of it, but at some point I do want to make sure we're talking about some of these rules, including if we're in 1.8 world and 1.7 world, I think the disclosures that would be required are incredibly helpful. I mean, 1.8 is very specific about what you have to do if you're entering into a business relationship with a client. And I think someone earlier was saying, what if I remember when I was a junior person, it was really fun, right? And my senior partner has a title company. If I was going to refer my client there, the rules are going to be very specific about what you have to be disclosing and at what level, so the client understands that material risk. And that material risk is we may not have aligned values or with my partner over here, and that's what could happen to you or not. I think there's incredible benefit to having that kind of structure and disclosure for the consumers of North Carolina. And I do think if you see, we attached some advisory opinions that people have received, including in 2017, that we've consistently followed. And I think there's a really good analysis of that aspect in it. I think you're muted. Again, it's hard to hear you.
I want to see if anybody wanted to respond to Mr. Zaleski's point or issues about disclosure under 1.8.
Well, can I maybe just for 2 minutes, Your Honor,
Yes,
if the comment that the attorney is the best place for the title insurance, we see what happens in other states when that does happen. I mean, we don't have to speculate very much. We can look at Georgia, we can look at South Carolina, which are pretty similar states. The claims paid in Georgia last year were, I think, around $5 million more than they were it's about 60% higher in Georgia than in North Carolina. The system that's basically being advocated for with a yes to any of those creates that system where the claims are just higher. It's just, the numbers don't lie. The consumer loses. Not only are claims a monetary issue that pushes rates up, and so rates will go up. I mean, it's a guarantee rates will go up if they say yes to any of these. But the consumer also doesn't want to deal with a claim. Having more claims is also just for lack of better terms, a quality of life issue for the insured. Even if you're going to win on your claim, and Nancy can tell you this better than me, it's still a headache for the claimant who makes a claim on their title insurance to have to deal with it. We should be out there to foster a system that results in a low claim environment for basically all respects. It's helpful for the consumer not having to deal with a claim, and it also pushes rates down. We have a uniquely good system in North Carolina in that respect as compared to similar states like South Carolina and Georgia. So I don't think it's correct to say. I mean, right now, lawyers have a kind of undivided interest in representing their clients to get good title at a cheap rate. When the attorney is also, what we see when the attorneys are in South Carolina and Georgia, they're basically trying to wear two hats at one time. They're representing the client, but they're also frankly representing themselves in maximizing the profit of their agency. And so you have things like attorneys not getting reissue rates for their clients and overcharging their clients for title policies in those states. And there's even a letter that was submitted to you where an attorney worked with Mr. Zaleski, and that happened with his firm and his agency, where there was an overcharge of a client. We just see that in other states, and the hand is just too close to the cookie jar in those states, and as a result, the consumer is the one who suffers.
Would there be some way then that, Jeff, as you're just talking about, where I don't know how to format this quite right, but the idea would be is that with some informed disclosures to the client, it appears that based on what Nancy was saying, most of the claims are not attorney related. There's something either before our search period or some other issue that's out there that's not us, to still allow the informed consent to occur. And in the event that it was discovered that the attorney was, say, not getting the reissuance rates or asking for an enhanced policy just to up the fee, that would be an ethical violation in some way, but still yet allow with the informed consent the consumer to choose to deal with an attorney who does have a title agency.
Yeah, it's a great question, Martin. I think the problem is that title insurance is something which the average home buyer consumer has a very limited knowledge about. The average person buying a house does not understand title insurance very well. You can be a brilliant person, but it's a niche industry, admittedly. And so they're very much reliant on the attorney who's representing them in the closing to do a good job in getting good title insurance that doesn't have that broad general exception that Kyle was talking about before. I don't think it's reasonable to expect in an informed, like, you're just signing these waivers or these consents. In the context of title insurance, I don't think that that's a reasonable thing. And, one of the changes that was made when 1.8 was changed in 2003, even then it talked about when there's going to be a business transaction between an attorney and a client, there had to be reasonable opportunity to seek independent legal advice in the context of that transaction. And I would argue that, to kind of going to your question, that really can't exist in the context of title insurance. It's so impractical in the context of a home closing to expect the home buyer to have the wherewithal and familiarity with title insurance to discern if they need independent counsel to look at a title commitment that was generated by a lawyer agency. I just think that's just stretching the bounds too much. So I think the answer to your question is I think it's really, really difficult because of the nature of title insurance and the limited familiarity with title insurance as compared to other products or other circumstances where a client may work with their attorney on a business transaction.
Nancy?
Oh, you're muted.
Just a couple of quick hits. And again, this is so nuanced because this whole relationship is so complicated. But number one, for smaller firms, there may be limitations on their ability to even qualify to get an agency. So you may be really disadvantaging sole practitioners or smaller firms because they may not be able to have an agency. I know in South Carolina, the ones who don't do that much and can't capture that business to justify, because it's a lot of work to support an agency. There's audits, there's requirements for CE and testing. There's a whole lot of work following up on remittances. Virginia has rules about that. I mean, there's a whole lot of administrative work that goes into it, as well as training to be an underwriter, not a lawyer, practitioner. How do you underwrite a policy? What are all the requirements? Why do you have them? How do you deal with endorsements? And, Craig could tell you 100 war stories of having to negotiate endorsements on commercial deals, and it's different with different underwriters. So there's a variety of underwriters. Small practitioners may be disadvantaged. You may be looking at dealing with one underwriter or two that you can work with, but the prior policies are with somebody else. So are you going to go to somebody else and ask them for the prior policy? Approved attorneys do it all the time, but they're usually approved for all of us or a lot of us. Without that prior policy, are you going to do tacking? And I would ask the ones on here if anybody even knows what tacking is and really thinks your client understands what tacking means, because it means some attorneys are not searching titles, but maybe 2 years and relying 100% on the prior policy. Does your client understand that? And if there's a title problem when you're doing the search, who do you charge? You shouldn't be charging the buyer or the title or trying to subsidize your income with the title premium. That's a seller issue. If there's some kind of issue that needs to be dealt with, the time to do that is when you're about to close and you've got the seller there and you can clean it up or do whatever curative you, in your legal opinion, working with your title company, feel like is what's best interest of your client, not insurance, avoiding a claim by cleaning up the mess and charging the appropriate party for it. And that's where this whole consumer protection issue and the bifurcation of what's going on is important to think of where the money's coming from and why the agency issue is important. They do it in West Virginia. They do it in South Carolina. They work it out. But those are the factors that really have to be looked at. Those are my last points.
Mr. Zaleski?
Yes, I wanted to go ahead and address the financial component of competition. Right now, if the bar says there is a continuing prohibition on attorneys cannot own title insurance companies, they'll essentially be continuing stifling competition in the marketplace. We know that competition is inherently good for consumers. That's been proven again and again and again. When you look at the title insurance companies side of things, right, it is they're getting fed business by the closing attorneys, and other than a handful, myself included, there aren't attorneys that are really. So when the when the title insurance policy is ordered directly from a title insurance underwriter, that title insurance underwriter will get 100% of the premium. There's a title insurance agency, the title insurance agency will take a portion of that premium, and the title insurance underwriter will get just a small percentage of that, maybe like 20 or 25%. So when you're looking at these title insurance underwriters and they're looking at all this direct business that they're getting from attorneys, if the things were to change and law firms were then to go ahead and have their own title insurance companies, what that would do is means the capture rate of the direct business going to the underwriters would decrease. That would mean a lot less revenue to the title insurance underwriters. I think Investors Title has a very strong direct business, so they are going to most likely experience a drastic, I don't know how much, but a loss in revenue. So I know you're hearing a lot from Investors Title, and there was a comment earlier about calling a spade. I just want to make sure we all realize that there are business interests at play here that will go ahead and affect everyone's perspective. And what I'm proposing is good for consumers. It might not be best for title insurance underwriters to engage in direct business. Most title insurance underwriters I've spoken to are actually neutral on it because they think that, well, we have agents and they'll go ahead and it doesn't really matter who owns the agency. We're happy to work with attorney-owned title insurance companies, but I know Investors has a very strong direct business, and therefore, that is a perspective that they have. I just want to make sure that we're aware that there's a business aspect to this as well.
Malia Williams.
Thank you. So a couple of thoughts with that. Naturally, there is a business perspective that's related to it, but I would echo back to what I had stated earlier, which is that our ethics opinions are in place to protect the consumer, not to enable us as attorneys to increase our revenue. Now, aside from that, as far as the competition side of things go, I'd be curious to hear Mr. Zaleski's view as to how that competition will actually roll out. Should the committee say yes, and the state bar would say yes to these inquiries when we are now a uniform bar exam state, and we do not have the infrastructure to support agencies across the board, as Nancy had mentioned as well, this is going to absolutely take out local counsel, smaller firms from being able to provide real estate services for closings in their counties, because they're not going to have the ability to support what is required of an agency and the minimum income and revenue that's to come in each year, in addition to the marketing and everything else. So if we have national companies that already do this as title companies, and we're opening the door to allowing mobile notaries, settlement agents, et cetera, whatever it may be, who are licensed and are, obligated to abide by our ethics rules, but aren't necessarily up to date with the best practices or the standard of care that has been expected historically in the state of North Carolina. I mean, the competition is not going to be attorneys versus attorneys and us, doing better by that portion of things. I mean, it's certainly not going to protect the consumer on that end. The competition is going to be nationwide with people that are licensed in the state of North Carolina, but are located in companies all over. But it still detracts from the consumer protection.
Craig Lynch.
Yeah. I just want to go back to something that Nancy mentioned, and that was this concept of endorsements. And it's basically extra coverage that you can buy for certain circumstances. And for instance, if I've got a transaction where I've got 4 parcels I'm acquiring, my client would probably like to know that they all adjoin each other. And there's this concept called contiguity, so that you make sure all the parcels fit together and you pay an extra fee for that. And I would tell you, I guess for better or for worse, a lot of my deals aren't confined to the boundaries of North Carolina. I'm dealing with other states, with other agencies that are providing title, and in general, the availability of those endorsements is much better in North Carolina. I have a list of about 25 that I typically ask for when I'm trying to get coverage for my clients, and they're typically far less expensive in North Carolina, which again, if we're talking about consumer protection, and I know price is not the sole pull star for that, but it's a good indicator of what kind of competitive practices and what kind of services people that issue title policies in North Carolina really kind of abide by.
Can I ask a question quick? Because I know we're hitting about 15 minutes left in our scheduled time, and there's a question as the staff to the committee that I know at some point I'm going to need to write something, and I've got a question, and it was kind of touched on before. The statutory provision we've been referencing. I know there's 5827.5 and there's 5826.1. The commissioner of insurance reached out to the state bar and said, basically, I'm aware of this inquiry and I'm asking the subcommittee to be mindful of 5826.1, the requirements there, and if there's any sort of expected change in the existing guidance. And Mr. Zaleski, I believe you had said before that you didn't think 5826.1 was applicable here, and I'm trying to understand that. I understand that it focuses on title companies, I guess, and this is really to that first question, not the imputed conflict question. This is just that first question that we've been going back and forth of lawyers potentially owning title companies, maybe serving both different roles here. But the language in here in 5826.1 talking about, no company can no such information shall be furnished, nor shall such insurance be so issued as the North Carolina real property unless and until the title insurance company has obtained the opinion of an attorney who's not an employee or agent of the company. And if you own the title agency and you're getting the insurance from the agency with which you're affiliated, how does that not apply here? And how does that not prohibit a lawyer from serving as both closing attorney and title agent? Oh, Mr. Zaleski, you're muted.
Muted.
The question that you asked was serving as a lawyer. The statute says that you shall not be an employee or agent of the company. And that restriction is only with regard to if you are an employee or agent of the company, you cannot furnish an opinion of title. That's all it says. That does not say that you cannot act as a closing attorney otherwise. Most law firms have multiple attorneys, and there's no reason why. And I know, if I'll speak for our practice, we have title attorneys who are very experienced, seasoned title attorneys that do the best title searches in the state of North Carolina, and they will do our title searches. I personally would never, do a title search.
So, and I don't want to. I'm sorry to interrupt you, but I want to clarify. Maybe if I've misstated, I'm talking about the single transaction where you've been asked to close the real property transaction, and you are also serving as you're telling your client for this closing, hey, I can get you your title insurance. I have my own agency, and I can take care of that too in this single transaction. Are you saying that you agree that that is a conflict and that is prohibited? Maybe not even conflict. Let's just say, is that prohibited by the statute?
No, because your question is, can you act as the attorney? The statute only prohibits providing an opinion on title. So to the extent that there's a prohibition, another attorney in the firm can provide an opinion of title, and that attorney can still act as the closing attorney for the transaction. And that's the key point. And also, whether or not that attorney is an employee or agent of the company is a question of fact. If they are, they can't provide the opinion. If they're not, then they can. I mean, if you are an attorney and you have a 5% interest in a title insurance agency, are you an employee or agent of the company? And the answer is maybe you are, maybe you're not. I think ultimately this highlights the point that it's really not for the bar to weigh into these insurance questions. We have the Bureau of Insurance for that. I mean, so I think that the ethics rules will determine the answer. And of course, the attorneys need to follow the applicable insurance statutes. If that attorney is an employee or an agent of the company, they cannot provide a title opinion, and they shouldn't. That's what the statute says. That's all it says. This whole idea that there's a conflict or they can't otherwise act as the attorney is something that's just been manufactured in discussion. It doesn't exist in the statute at all.
And maybe I'm still forgive me if I'm just being kind of boneheaded about this. If it's a solo practice and you are the closing attorney, there's no other attorney in your firm, can that solo practitioner who's doing the closing also be the title agent under the statute?
If they can be the attorney, but if they are an employee or agent of the title company, they cannot provide an opinion to that title company.
Okay.
And I think that you're looking,
yeah, I want to be on the same
looking
page
at providing an opinion to the title company, meaning more than just that. And I'm saying that's all that it says. We can't look at that as serving as an attorney. And because in firms that are more sizable, normally there is a group of attorneys that do all of the title opinions for all the other attorneys because they're so good at it. And you get that kind of efficiencies built into the firm.
Okay. And that, I guess that's speaking to the imputation issue that's also part of this. Okay.
Which is a separate issue.
There's an assumption being made, though, that you have multiple attorneys in every firm almost. I mean, I'm still gonna go back to what Brian's asking, and I think we just need to get that fundamental thing answered, and then we go from there. If you have one attorney in one firm that is also has a title company, does that then preclude by either ethically and as well as 58-26-1, that would then prohibit that one attorney from being able to be the certifying attorney to the title company that the attorney owns? So that's a no-no, correct?
I don't think that's a per se rule, because the statute says that you cannot provide an opinion on title if you are an employee or an agent of the company. It doesn't say that whether you own the title company. And so you can own a title company and not be an employee of it. You can have an ownership interest in the title insurance company and not be an employee of it. Whether or not you're an agent of a company is a question of corporate law. I can't tell you. So what I would say is, if that solo practitioner is an agent of the company, then probably. However, this statute applies to the underwriter, not the agent. And that's the other aspect here that we're missing. Because when you read the statute, this is the statute that creates the ability of title insurance companies in general. And it goes ahead and speaks, if you look to B1 of the statute, it talks about the capital surplus deposit and investments requirements. That is the requirement of the title insurance underwriter itself. Those are the large national companies. Whether the statute applies to the actual agency, which would be a different company that would be an issuing agent for the underwriter, I think is a separate question. I think ultimately that's an insurance question, not a legal ethics question, because we have two things going on here. We have legal ethics and we have insurance regulation. Leave the insurance regulation to the Bureau of Insurance, and we all need to decide here what the legal ethics are.
Are you making a distinction then between acting as an agent and being a title insurance company?
A title insurance company and a title insurance agency are not the exact same thing under the statute. You have underwriters, and you enter into an agency agreement with the underwriter, and then you become an issuing agent for the underwriter, and that's the title insurance agency. This statute, 58-26-1, is referring to the underwriter. That's my point.
So that's what I was wanting to make sure. So what you're saying is there's a distinction between being an agent that may seek out as like a mortgage broker. If I'm a mortgage broker, I'm not a lending company, but I'm a mortgage broker. I seek the best deal I can for my client. Of course, I do receive money for doing that. And so you're saying in this situation, this statute only relates to if I'm the actual title company.
That's how I read the statute, yes.
Okay.
Judge, I see Nancy has her hand up.
Yeah, Nancy.
I think there's an absolute difference between agents and underwriters. Nathan's exactly right about that. I mean, it's a huge difference, and I think that's a whole nother part of this conversation. But that statute, any policy that's issued is on an underwriter. So any agent is still subject to that statute because they're issuing it on behalf of us as us. I don't work for an underwriter anymore. I'm independent, but investors, Chicago, Fidelity, First American, whoever, anybody, any one of us, our agents are actually writing on our paper, and they're subject to the things that are going to limit us. We may be the ones who have the surplus and pay the claims, but all of our contracts are going to require that they be compliant with North Carolina law, and that they are signing as agents for us, and we have to comply with that statute. So I think it does really apply to that, just like issuing CPLs, closing protection letters, et cetera. So whether you say that's two-step or single step, that's applicable.
So in the language, the direct language of the statute that says, and not an employee or agent of the company, that means that that agency there would be like a general agency idea, that whether you are in the firm, the underwriting firm itself, or you are acting as an individual doing a referral, an agent, that's still an agent. It covers both. So Mr. Zielinski's wrong about his interpretation.
Yes.
That would be an interpretation, but he's right that there's no case law on it. I mean, I don't like it. It's an old statute.
Right.
And life is much more complicated now than it was. I'd like to say it was clear as day, but I can't say any of this is clear as day because life is full of complications. But I can say that even though we have this statute, in arguing that we're out of sync with the rest of the country, that's really not a helpful argument because most of the rest of the country doesn't have attorneys involved at all. They have title plants, they have title agencies. I think my thought is we need to focus on where we are here and what's the best for North Carolina.
Agree with that.
And I would say, all of these comments really highlight my biggest thing would be to ask this committee to be very clear in whatever rule they reach, especially, I think Brian highlighted at the beginning. I think we have a pretty clear answer to inquiry one, well established. I think we have a consensus in the legal community as to what everybody believes the answer to number two is as well, with some limited exceptions. But no matter what the committee decides, it is very important for it to be very clear and very unambiguous, because right now we have a situation where some participants in the market believe the bar has answered inquiry two affirmatively, and many, do not. So I would just say that's a very important question. I don't envy the position you all are in, but clarity is very important because people are playing by two different rule books right now.
Well, is this a good place to leave things? We're running out of time, and I'm afraid we might start a new discussion.
I was going to say, I've got another question, but that's probably going to lead to like an hour of discussion.
Why don't you ask the question, and it's something we could think about before the next subcommittee meeting?
Well, I think I think we need to be mindful of statutory interpretation and prohibitions that may exist or whatever, including our ethics opinions. The question I was going to ask regards disclosures, because I think that is really starting to hit on the head of this question of not the attorney who's serving as in both roles, or is purporting to serve in both roles, but when you have the imputation question, you have the partner that owns a title company, and I guess that's the question of disclosures that I know there are some situations where we say disclosures are appropriate and effective for waiving any potential conflict. And then there are other situations where we say there's really no disclosure that's going to be sufficient. That's not going to be enough to cure. And so I guess that was going to be my question about, are we comfortable asking consumers in this particular transaction to understand and rely upon an attorney's disclosure to understand the kind of nuances for this necessary component of their transaction. And it really goes to the nature of disclosures. And I think maybe that's something that we need to ponder and continue to discuss as it relates to this concept of conflicts. And now understanding, of course, when I say disclosures, I'm kind of presuming that a conflict is at least kind of perceived. If not, we're saying it exists. And I don't know that everybody's wanting to, make that conclusion just yet, with regards to the imputation of conflict. But still, the disclosure question, I think, is one that we do need to explore. So perhaps, Judge, I don't know how the subcommittee feels. If this is something that we need to kind of get the band back together and continue to talk at some point or what have you, but maybe we can figure that out in between quarters and certainly find another time to meet and let everybody know.
All right. Well, thank you all very much. It's been a very respectful and robust discussion this afternoon, and it'll be a continuing conversation. Counselors, I'll see you next week.